Hi, my name is Latasha Barnes, Senior Staff Attorney with Land of Lincoln Legal Assistance Foundation, and today we'll be talking about the basics of student discipline reform under SB 100. Effective September 15, 2016, the School Discipline Code was amended to require school districts, both public and charter, to reconsider the way that they implemented discipline at the elementary and secondary level. This provision of the code can be found in Section 10-22.6. I encourage everyone to read the statute. It's very important. There's a lot of really good information out there. So how do we get to this place where discipline needed to be transformed or reformed in the state of Illinois? Well, it all started with an organization called Voices of Children in Chicago Education, or VOICE. VOICE is a youth-led organization whose goal is to increase graduation rates and to help student preparedness for college. The organization performed a lot of research and studies, and they found that the manner in which discipline was being implemented across the state of Illinois was both costly, ineffective, and had a discriminatory impact. The data that was collected by these young people indicated that over 300 suspensions were implemented during the 2012-2013 school year. This resulted in over 173,000 instructional days lost for students grades kindergarten through 12th. The data that they collected also indicated that a large majority of these offenses were for nonviolent misbehaviors. Behaviors such as disrespect, tardiness, being out of uniform, some of those less serious offenses. And the data that VOICE found was very consistent with data that had been collected by the Office of Civil Rights, which indicated that approximately 95% of student discipline across the nation was for nonviolent offenses. The young people were very alarmed. Our Congress was very alarmed, and so Senate Bill 100 was implemented. The one thing that's important to remember or to know about Senate Bill 100, although it changes the way school districts should look at discipline, the most important thing is that it is intended to produce a more positive school environment. A lot of the data that was collected by VOICE and a lot of the data that is available nationally really shows that student discipline can have a very detrimental effect on the students' well-being, on their self-esteem, and their emotional development. In addition to that, instead of creating a more positive school environment, it actually affected the way students viewed school administrators and school staff. It led to a decrease in graduation rates and really had a very opposite effect. A lot of the data indicated that it was not improving student behavior overall. And so a lot of recommendations, best practices had been released and promoted to help us improve student behavior and create a more positive school environment. Some of the best practices that have been recommended over the years that have been adopted in SB 100, including requiring districts to develop memorandums of understanding with local law enforcement agencies that clearly define the role of the school district and the role of law enforcement in the disciplinary process. Another intervention includes requiring districts to develop re-engagement policies so that there are opportunities for those students who have been excluded, because sometimes it is necessary for students to be removed from the school environment. But the re-engagement policy requires districts to meet with those students, to perhaps meet with those families, and to help that student become reconnected and feel reconnected to the school environment again. Another intervention that was adopted is the requirement that districts allow students to make up work. This will help offset the effects of lost educational opportunities, and we hope will improve graduation rates in the end. Another point that is important to remember about Senate Bill 100 is that it is designed to limit exclusionary practices to the greatest extent practicable. Not altogether, but I think it's important to realize that it is designed to limit how often we use suspensions and how often we use expulsions and disciplinary placements as a form of discipline. The bill's intent is to help school district officials think through non-exclusionary ways to address student misbehavior. The Illinois Principal Association has a list on their website that suggests various ways that districts can implement discipline without excluding students from the educational environment. These include in-school suspensions, detentions, removal of student privileges. Perhaps if a student has engaged in an act of misconduct, we don't allow that student to attend a field trip or a special class activity in lieu of requiring them to miss the school day. Other alternatives might be behavior contracts or safety plans, those types of interventions that address the behavior specifically and help to craft remedies so that that student is not engaging in those behaviors, or that we limit their opportunities to do so without removing them from their educational environment. The way that SB 100 limits exclusion is by setting requirements and requiring school districts to now rationalize why they are disciplining a student in a particular manner, specifically if that discipline is going to be exclusionary. Which brings me to my third point. Senate Bill 100 is now requiring us to do something we've never done before. Think about why we're implementing discipline in a particular case. What are the facts of this case? What is the underlying motivation behind this behavior? And is this something that we have to remove the student from the school environment to address? And by now requiring school districts to put those reasons in writing, to clearly articulate what the legitimate educational purpose is of the discipline, Senate Bill 100 is giving us an opportunity to rethink the motivations behind these behaviors and to make sure that we are not implementing discipline in a way that is overly harsh or that may be unfair to certain groups of students. I hope this has been helpful in giving you a better understanding of SB 100. In the end, it's really important to know that although this law sets new parameters, it requires new things of us, it has a lot of technical aspects of it that may increase paperwork and things that we have to do on our end. It is ultimately for the better of the school environment. It's the best thing for our students, and it is designed and crafted around what research has proven to be a better way to implement discipline. For more information about Senate Bill 100 and student discipline, please view my full presentation on the ISBA online CLE archives. And for additional information about the great benefits of joining the ISBA Education Section Council, which sponsored this CLE program, please visit the ISBA website. Thank you.